Welcome everybody to this historic first virtual flag meeting. We've got three wonderful speakers on IP enforcement, software audits and the Internet of Things in the context of security, and I will introduce those speakers fully before each talk. Before we start, there are some housekeeping points as usual. Each talk will be 25 minutes and there'll be 5 minutes for questions at the end, but do feel free to put your questions into the Q&A system at the top of the screen rather than the chat, and they can be waiting for the speaker when they've finished. If you are a FAST flag member already, well done. If you're not, please consider membership. You'll get our quarterly legal updates. You'll get the facility to get anonymous whistleblower reports as appropriate to your organisation. You'll get our wonderful new online meetings and our in-person meetings when they're allowed that are normally only open to members. And you'll get the opportunity to host flag meetings as they go forward as well, co-host them with us. There's more details at fast.org on our website. And thank you very much to Stephenson Harwood, David Berry for working with me to host this meeting, and their IT team there for providing the tech and for recognising the benefits of membership. So I'm going to move on to our first speaker now. The first person to speak is Meg Heap. She's Head of Strategy Development and Delivery for IP Enforcement at the Intellectual Property Office. And they're currently consulting for IP enforcement strategy for the government, and she will tell us all about that. So the Q&A is the time for direct input to the corridors of power here, which is invaluable. Over to you, Meg.
Thank you very much. Thanks for that lovely introduction, Dawn, and hello everyone, and thank you very much to FAST and Stephenson Harwood for inviting me here today to talk to you about the government's strategy on intellectual property enforcement. Intellectual property rights, or IP rights as they are also known, are important because they protect intangible assets. And of course, as FAST members, protecting intangible assets is your core business. But what are intangible assets really worth? Well, in 2016, the Office for National Statistics found that investment in intangible assets was £134.3 billion, and an investment in intangible assets was £148.5 billion. And the data also showed that investment in intangible assets is growing more rapidly. So this really means that actually half of a company's value lies in their intangible assets. And as a result, the need for protection of these assets becomes very clear. This is why, as part of its role, the Intellectual Property Office is responsible for supporting enforcement of intellectual property. However, while the government and the enforcement agencies play a key role in ensuring the framework for tackling IP infringement is up to date and accessible, industry does play a critical role in enforcing IP rights. And it's therefore vital that we understand where you think the strategy should focus in the next 5 years. So if we can move to the second slide, please. So the IPO, what is the Intellectual Property Office, also more commonly known as the IPO? Well, it's the official UK government body responsible for intellectual property rights. It operates and maintains the intellectual property system in the UK. It's really trying to seek to encourage innovation and help the economy and society benefit from knowledge and ideas. You may also know it as the Patent Office, and I still hear that quite a lot actually. That's what it was called when it was first set up back in 1852, primarily to grant patents. Its functions have increased tremendously since that time, and it now covers the granting of not only UK patents but also trademarks and designs. And in addition to its right granting function, it is also responsible for government policy on intellectual property, and that includes copyright in addition to patents, trademarks and designs. And it has a specific responsibility on educating both businesses and consumers on IP rights and responsibilities. In addition to all of this, as I mentioned earlier, it is also responsible for supporting the enforcement of intellectual property. However, and this is quite important, the IPO is not an enforcement agency. Instead, it works very closely with enforcement agencies such as the police and trading standards, and our role is to provide the effective enforcement framework that enables them to carry out their enforcement duties. So on to the next slide then. This is our enforcement team. And the enforcement team at the IPO carries out a really wide range of functions. Not only are there 3 policy teams covering issues such as our international work, our capacity building and our outreach, but we also have an IP crime intelligence hub. And this team includes researchers, analysts, intelligence officers, and actually largely thanks to the last IP enforcement strategy, we also have financial investigators as well. These teams work extremely closely with enforcement agencies and other government departments. However, we do recognise that nothing can replace having dedicated IP resources in some areas. So we also fund 2 posts in Border Force and half of a post in the police. So next slide. Why is enforcement so important? Well, simply put, an IP right, whether it be a patent, a trademark, a design, or something that is protected by copyright, is worth nothing if it can't be enforced. And it is these IP rights that enable businesses and individuals to benefit from their investment. If these investments were not protected and their IP rights were not enforced, there would be less incentive to focus on research and development, which in itself would reduce innovation. However, it is really important that this framework is balanced. While these incentives are really key in rewarding creators and encouraging innovation, we also need to enable a competitive market, and we need to have a system that works in the public interest. New innovation relies on existing information, and without public access to that information, you wouldn't have the same level of discovery and creation. So what is the actual cost of infringement? As you can see, there is a cost both in terms of the economy, but also harm to the community. On the economic harm, this has risen significantly. It's gone from £4.2 billion of foregone sales due to counterfeit and pirated products in 2013 up to £9.2 billion in 2016. And by the way, in case you're wondering why I'm referencing 2013 and 2016 figures, the data is always a few years old due to the time it takes for them to be released and shared and then normalised and then pulled into reports such as this. So back to the harm. The harm to the community is just as important as the economic harm. Consumers who purchase illicit goods, whether knowingly or unknowingly, can fall victim to computer malware, to identity theft, or be exposed to inappropriate content, and there is an impact on communities of losing legitimate businesses. Not to mention that the profits often go to criminal organisations. So quite significant harms here. If you go to slide 5. Thanks. So to help focus the government response to these issues, the IPO has an IP enforcement strategy. As you can see, the last strategy was published in 2016 and it's taken us to May of this year. So in line with those 3 aims that show on the slide, the strategy looked at 6 specific areas. The first was reducing the level of illegal content online, and the second was tackling the trade in counterfeit goods, so very much this piracy and counterfeit elements. The third then looked at further strengthening the legal framework to facilitate easier access to justice. So this is very much around SMEs being able to actually afford the costs of court. We have our IP Enterprise Court, which has been really successful. The fourth was on increasing education, awareness and building respect for IP. So looking at consumer behaviour. The fifth then was making it safer for UK rights holders and businesses to trade internationally. And the last was improving the evidence base, because really it all comes down to evidence. We need to understand exactly where the challenges are to know where to focus our resources. So over the last 4 years, we've had some excellent progress in the areas that were identified within the last strategy. For example, we have delivered voluntary agreements with search engines to demote copyright infringing websites. This really helps to ensure that it is the legitimate sites that are those being seen by consumers. We have also developed the capability of our intelligence hub in the IPO so that we can now carry out financial investigations, and this has been really successful. We have also continued to fund and build on the success of PIPCU. PIPCU is the Police IP Crime Unit, and it was established back in 2013. We have also delivered a lot of IP-specific training to police, to trading standards, and to industry brand protection staff all across the country. So really getting that, raising the profile and the awareness and the understanding of the issues. And lastly, we've also pioneered the world's first research into consumer attitudes to buying counterfeit goods. And this will complement our existing research into copyright infringing activity, and it's a really significant step forward in understanding consumer behaviour across both piracy and counterfeits. So if we could move to the next slide, please. So where do we go from here? Well, we're planning to publish a new strategy early next year, which will take us through the next 5 years. So unless the last one's a 4-year, this will be a 5-year strategy. It's a very different landscape ahead of us, both in terms of our international relationships and the rapidly evolving online environment, something we're very conscious of. With the UK taking its independent place outside of the EU and the new trade deals we are forging with countries around the world, we recognise there is currently a lot of uncertainty. And this can be very nerve-wracking, but it can also provide some great opportunities. And we really want to use this strategy to be ambitious. So we want to ensure that we are supporting UK businesses and innovators, not only with the trading partners that we already have and do value greatly, but also to enable you to reach out to new countries, while feeling that your IP is protected and respected, and that you have access to justice if needed. We do actually currently have a world-leading IP enforcement regime. We score very high in the global rankings. And first and foremost, we really want to maintain this and continue to be recognised internationally as a leader and innovator in this area. Part of this is really about maintaining our effective and balanced framework, but the other part is actually really about thinking outside the box. We want to push the boundaries to see what is truly insurmountable and what is challenging but still actually possible. Technological advances can be an amazing tool in the fight against infringement, but they can also be used by those infringing, allowing for a much quicker and wider proliferation of illicit goods, both domestically and across borders. So we need to ensure that our enforcement framework is moving with the times and works for the digital age that we are in. Technology evolves so quickly, this is a really challenging area, and we need to be able to adapt and tackle these changes in real time. It's not an easy thing when looking at legislative frameworks. That is why we want to look at how we really can be truly flexible and forward-looking. But most of all, to be truly world-leading in this space, it is critical that we work collaboratively with all parties, and that is both public and private, acting at every level and using all possible tools available to us. And this is why I'm here today, to help raise the profile of IP and enforcement, and to ensure that you are aware of our work and are able to feed into it. So if we could move to the next slide, please. So looking at where we are so far with the strategy, we currently have drafted 3 core strategic aims. which have been pulled together to help provide a clear vision of where we want to be in 5 years and how we can best get there together. These aims focus on 3 main areas, and that is leadership, partnership, and education. On leadership, this is about how we remain that world leader, striving for that gold standard both domestically and internationally, and really about making the UK the best place in the world for businesses to start and grow. On partnership, this is about collaborating with partners, both domestically and internationally, yet again. And when I say partners, I really do mean, again, both public and private. And on education, this is about empowering consumers. So for some consumers, it's really helping them to identify illicit goods, something that the online environment has made harder in some areas. For other consumers, it's about helping them to understand the benefits of buying the genuine goods and the wider harms of buying illicit ones, some of which I referenced earlier. And in this space, we are working towards a time where infringement is seen as socially unacceptable to all. It's a big aim, but an important one. So we will be looking at any emerging issues in the strategy against these core strategic aims, and we will use them then to identify potential actions. For these aims to be effective in steering our work, they need to be right. So it really comes back to the fact that we need to hear your views on them and on all of this work. So on to the next slide. Thank you. We recently held a series of workshops with industry and also included academics, government departments and enforcement agencies, and it was great that FAST were able to attend these. They were incredibly helpful in understanding some of the emerging issues in more detail, and also provided an opportunity for additional areas to be raised by participants. So the slide obviously shows some of the issues we've looked at, but one of the hot topics at the workshops was actually the role of intermediaries, where illicit goods are being advertised, shared and sold through them. And this is becoming ever more important due to the increasing access to and use of online platforms and marketplaces. And alongside this, the increasing access to and use of both content and access to illicit goods online. So some great steps have really already been taken in this space, but we are aware there are still significant challenges. We will be meeting with a range of intermediaries soon to discuss some of these issues that were raised at the workshops, and this is, I think, will be a very exciting piece of work. Consumer behaviour, the next one on the slide, was also another area of great interest, both in terms of those who are knowingly and unknowingly infringing. And getting information to those who need it on how to identify illicit goods is not an easy thing. No, we're not going to pretend it is. And particularly, neither is changing mindsets. So we really need to look at who we're trying to reach, what our message is, the best forum for sharing it, and also, quite importantly, who should be giving that message, who would have the most impact with the people we're targeting with this. This will not be a small piece of work, but it is something that the IPO is very committed to. It's not just going to be in our enforcement strategy, it's in our office strategy. And we will be reaching out to partners on how we can work together on a targeted campaign. So these issues on this slide, the other ones, are by no means all the issues that have been raised by stakeholders, but hopefully they give you a bit of a flavour of some of the emerging issues that we will be looking at in more detail. If you think there are other issues that we should also consider, again, we would love to hear from you about them, because we want to ensure that we are covering all the key challenges ahead. So on to the next slide, please. So what is next? So firstly, it's just really echoing, I think, something I've said a few times now, but we want to hear from you. Whether this is through FAST or directly to me and my team at the IPO, we want to ensure that we understand how you see this area evolving over the next 5 years, What do you think needs to be maintained because actually it's working really well? What you see as the biggest challenges over those next 5 years, and what would really be the best outcome that you would like to see in this space. We'll then be using all of the information and evidence to identify the emerging issues and the potential actions, looking at them against the entire supply chain. We will work with our partners, again, both public and private, on how these can most effectively be taken forward. And that may be by government, it may be by enforcement agencies, it may be by industry, or it may be by a few of us collectively. And we will look then at how we can monitor and assess these actions stemming from the strategy, really ensuring that we are meeting our objectives and commitments and also able to adapt in line with any technological advances or unforeseen challenges, such as a global pandemic. But yeah, that's the next steps. So just onto the last slide, please. So I just wanted to say thank you very much for the opportunity to speak to you all today. I really hope this has been helpful in understanding the value of protecting your IP and for giving you insight into the work that the IPO is doing on the government strategy for IP enforcement. Please do get in touch with either FAST or me and my team if you would like to discuss IP enforcement and the strategy in more detail. My email address is on the slide, along with that of our team inbox as well. So please use them. Thank you. So I think we're on to Q&A next.
Yes, Meg, thank you very much. I think you gave everybody everything that they need, a toolkit to get in touch with you. I see at the moment that we don't have any Q&As yet, any questions yet, but I have one to kick the ball off while getting their questions together, and that is, if someone said, oh, but surely with the pandemic we're not going to get any attention for this at the moment, what would you say?
I would probably say it is definitely a difficult time to move forward on some things, but actually I think the pandemic has highlighted where counterfeit goods and pirated goods are having a huge impact on our society and our economy. And we can't put these things aside, so we really do want to take this work forward.
Okay, any more questions at all for Meg? Meg, can you see there's a Vaughan Chadwick question? Can you see it?
Yeah, thank you very much. Yes. So do you find that IP theft in software is an increasing concern, or have publishers reduced their demands for this? It is definitely something that is still coming up. I'm not sure if I would say it's increasing or reduced. It seems at the moment pretty level. So I'm not sure what that would suggest, but it's definitely something that's on our radar for the strategy.
Any more? In which case it just remains for me to say, if I can get my video up, thank you very much, Meg.
Thank you.
And we will move on to David Berry, who is our next speaker on software audits. He's a Senior Associate in Commercial Outsourcing and Technology at Stephenson Harwood. They're our kind hosts today. He's going to tell us what a software audit is and how they can be important and valuable for software rights owners. Okay, David, over to you.
Thank you, Dawn. Good afternoon, everyone. As Dawn said, I'm David Berry, a Senior Associate in the Technology team here at Stephenson Harwood. A significant part of my work largely involves drafting and negotiating software licenses for both customers and suppliers. I've also been involved in supporting our clients during software audits, particularly assisting in reaching trying to at least reach amicable solutions for both sides when there's been allegations of under-licensing, when essentially the licensee has used the software outside of the scope of its license rights. And really the aim for this talk is to give a fairly short introduction into some of the basics of software audits, but also to touch upon some developments that we think are interesting and some other topics that we thought might be helpful for everyone listening. So I suppose to start off with, I think it's important really for me to sort of emphasise or help clarify what I'm talking about when I'm referring to software audits. Essentially, it's a contractual right for the licensor to review the licensee's use of the software to ensure the licensee is using it in compliance with the contract. Now, this is largely how the licensor is able to police the licensee's compliance with its obligations, particularly regarding the licensee's use of the software and who it allows access to it. Now, often, what the licensor is looking for is whether the licensee is using the software within the prescribed metrics it is paid for, such as the number of users, whether it's for a specific location or for a number of transactions. There's a whole myriad of metrics that they can potentially use. Now, a software audit is usually conducted when the licensor believes that the company or the licensee is in violation of their agreement. However, some licensors can make this simply an annual process as part of their general governance regime. Now, I don't think it's an exaggeration, and certainly hopefully for those listening that are in the IT departments of certain companies, but it's true to say that it can give IT departments sleepless nights. I think while some customers have large sophisticated IT departments to help monitor software usage and compliance, this is not always the case for many customers. And in any event, such audits can be just as stressful for the large organisations due to the potential scale and cost of any under-licensing if they get it wrong. Imagine, a company with 1,000+ employees and potentially users of the software. This could seriously be quite a significant cost. And in what I'm sure is the majority of cases, such under-licensing is often a mistake or simply based on a lack of understanding of the permitted use and the scope of the licence. This can be a result of, which I'm sure some of you are familiar with, some confusing software license terms or certainly overly complex license terms, potentially new computing models such as virtualization in the cloud, which I'll come on to later, or just a basic lack of software management strategy and really understanding or real oversight over how the software is used. And a simple example of that is when, imagine a parent company purchasing a software license, assuming that license will extend to its group companies. However, most licenses are personal to the contracting party, and that any use by the group companies sort of beyond the parent company or the main holding company could essentially be a breach of the license. Now, licensors rightly want to ensure that the software they use and make available to the licensees are being used correctly, but often the complexity, as I've said, of this software scope of permitted use can make these breaches of the licenses, almost inevitable. So while I mentioned that a key driver behind the software audits is an attempt to combat software piracy and good contract governance, I suppose another obvious one is, and it shouldn't be underestimated, that settlements reached with non-compliant organisations is a huge source of revenue for software vendors generally, or helps them in their ability to move customers onto new products. Now, with regard to the audit itself, a company is usually served with a notice for being audited by a software vendor. It's likely to include details regarding what software is being audited and the time period for which they have to respond to the allegations. And like any audit, it's really important that the parties need to ensure that the audit scope is agreed in advance so that the licensor doesn't go beyond its contractual rights. And depending on the software vendor, the notice can at times be quite confrontational, but good vendors try generally to approach it in a more cooperative way because after all they want to retain their customer. But when a customer is faced with an audit, it's important to realise that this is both a legal, technical and commercial process. And really need to emphasise that because I think you'll always need the legal team engaged to manage the contract review, to help settle the settlement negotiations, as well as ensuring that the audit scope, as I've mentioned, is sufficiently narrow. And the technical team will need to review and often explain to lawyers like myself how the software actually works and how it is accessed in practice. And actually both the lawyers and the technical teams are very important to assess actually the merits of the claim, because sometimes the actual allegations may not be true or may not be founded on sort of substantial evidence. And then the commercial teams are just as important because they need to negotiate or help negotiate any potential settlement and figures, whether that's a monetary amount or the agreement to purchase new software in satisfaction of that under licensing. Now, often software vendors see this as a license breach as a great opportunity to introduce new products. And we've seen, certainly in the more recent times, that software vendors really try and use this as an opportunity to migrate certain customers away from what is the traditional on-premise, like downloaded software to the machines in an organization, to try and migrate them more to the cloud, to sort of SaaS, software as a service-based products instead. And certainly the industry seems to be moving that way. And we've definitely seen this used as a tool to help try and migrate, rather than take a monetary amount of settlement, trying to reach agreement to try and move onto this new platform to help sort of, as part of the licensor's wider strategy. And the best way to mitigate the outcome of audits is really, it's fairly obvious, but it's to try and conduct regular internal audits or hiring a third party to do it for you. There's also software on the market to help assist in managing a company's software assets as well, and those should be considered. And a particular tip we've certainly noticed, and we would advise certain clients, is at the end, during the negotiations and at the end of it, once you've sort of landed on what the metrics are, is to actually create a summary of the license in order for in future for you to map against your use of the software as it's going to develop over time. And as mentioned before, the consequences of such breaches of licenses can be significant, with the claims often reaching the millions in unpaid license fees. And the majority of time, these disputes are settled between the parties, as there's a risk from both sides, obviously, with litigation generally. You potentially roll the dice, it's very expensive, and so often both sides are reluctant to take these to court. But in particular for the licensor, who, if the courts find against them, could really undermine their business model. And just turn it on its head. And however, there have been a small number of cases, and one of which I'll touch upon, which at the time had the whole software industry waiting with bated breath. I can't emphasize that enough. It was really surprising that it actually made it to the courts, because except for the reasons just mentioned, that this really could have had a serious impact in the licensor's business model. And that case was SAP and Diageo, which I can proudly say I did assist in. But by way of a background, Diageo had licensed some software from SAP called My SAP Enterprise Resource Planning, or ERP for short, from about 2004. This managed a number of things such as manufacturing, stock and supply chain, financial reporting, and various HR requirements. The license to access and use the ERP software directly or indirectly was on a named user basis. And fees for another piece of software called SAP PI or SAP PI were calculated on the volume of messages processed through it. The other software, so the SAP PI, distributed messages and certain interconnectivity between the ERP software and other SAP systems, as well as non-SAP systems. And I think it was between 2004 and 2015 that Diageo, I think they paid somewhere between 50 to 60 million pounds in license fees between that time. So certainly not an insignificant amount of license usage for that kind of fee. But interestingly, it was around 2011, Diageo developed and introduced two new software systems, one called Connect and one called Gen 2, using a platform provided by Salesforce. Now, Connect enabled Diageo customers and distributors to place orders for products directly using this online platform, rather than historically through the Diageo employees in a call center, who would then use the ERP software to process orders as named users. Gen 2 will use some similar technology, but that was to manage the operations of Diageo and sales and service representatives, and had a similar sort of level of connection with the ERP software, and almost kind of replacing the traditional named users' use of what the software was created for. Now, Diageo accepted that Gen 2 and Connect interacted with the ERP software via the SAP PI system, but disputed whether that interaction constituted use and or direct or indirect access to this software, so as to give rise to payment of additional fees. And SAP, on the other hand, claimed that Gen 2 and Connect used and or accessed the ERP software without them being appropriately compensated under the named user pricing arrangements that they'd agreed. And as a result, SAP claimed additional license and maintenance fees of approximately £55 million, which is essentially the same amount of their entire license fees to date. So you can kind of clearly see why they, or how they arrived at that figure, but really astronomical figures there. And you could see clearly why Diageo would want to defend themselves in such a context. But to SAP's and the software industry's relief, the court did find for SAP on liability, but did not make a ruling on the amount of compensation due to SAP. So the judge held that the SAP PI software was not a gatekeeper for access to other SAP applications. So it didn't give authorization to use other SAP or even other software just because you've got a license fee for SAP PI. The charges for that software were in addition to and not instead of the individual charges you would have for those particular applications. But what was difficult here is that there was no named user category for this type of usage in the schedule that was in the contract agreed between the parties, based on the type of access that was granted by Diageo's Connect software to the SAP software. And that's largely why the judge ruled or held off ruling on quantum at that stage. But what's important here, I think this is a great example of software licensing language that was agreed many years ago, finding itself being applied to new technologies and interfaces in a way that just wasn't anticipated or envisaged at the time the agreement was signed. Now, I think this is a really important point that I think for the purposes of this talk that I wanted to get across is that this is going to have such a significant impact with the increase of automation where the user may be replaced by a software function that interacts with the licensee software and essentially still uses the functionality of the software, but in a different way. And in particular, as machine learning and AI continues to develop at pace, it's going to be really interesting to see how the different software will interact with each other with limited traditional user input. So you can imagine, me being a user traditionally, my role in that transaction or use of that software can quite easily now be replaced by other software just simply doing through automation running those transactions, but isn't your traditional named user. As a result, it's going to be so important for both the licensees and the licensors to give real detailed thought as to what the charging metrics will be and what are appropriate given the circumstances, and also as much as you can to try and future-proof this. And whilst it's common during the contracting stage for the parties to assess and define the type of users and access rights in the contract now, but even more so, careful thought now needs to be given to the level of interaction between the different softwares that are going to be interfaced with it, and whether this could inadvertently fall within the definition of a user or a transaction and attract further charges that you weren't necessarily expecting. Now, not to alarm FAST or flag members with that sign, it's with the new technologies in mind, and referring back to cloud computing, it's really interesting to see the development of software as a service or cloud computing and its impact on the software audit clauses more generally. And this is, I suppose, to some extent quite anecdotal evidence at this time, but certainly I've seen it enough now for it to worth a mention, and just to get people to think more clearly about this, and both from the supplier side and the customer side. But just for everyone's reference or benefit, the key distinction between sort of SaaS, software as a service, and on-premise sort of downloaded software to the machine is where the software is housed and how it is accessed. In a SaaS environment, in theory, the licensor retains a lot more control and oversight of the software as it sits on its systems. So in sort of what, as opposed to what would be historical breaches, of licenses, the licensee in this instance with a SaaS environment is likely to need to be a lot more conscious or make a lot more conscious choice around breaching the terms of a license, such as knowingly and purposefully sharing login details rather than incidental and accidental use beyond the scope of its contract. And we're certainly seeing, as I said, while it is anecdotal at this stage, we're certainly seeing licensees pushing back a lot more on software audit rights within the cloud contracts, based on greater control the licensor has and visibility over access and usage rights. The success, however, of such arguments is largely going to depend on the level of control the licensor has in practice, and whether this will be sufficient to be the death of software audits remains to be seen. So I think certainly some FAST members can breathe a sigh of relief, but It's certainly something to watch in the future, and something not just to be blindly entered into. I think this does need a lot more thought, and I think we're going to see a lot more development on this in the future. Now, just on the final point I wanted to mention, now while this is I'm sure you'll agree, a really whizzy slide, and by no means drawn by my 6-year-old child, one of the important points on this one is really to sort of touch upon is software license in a corporate transaction and in corporate deals more generally, which I don't think get enough attention. This really revolves around the question of who can actually use the software on behalf of the authorized licensee. The precise license provisions will obviously need to be carefully reviewed in this regard. But I think what people will be fairly familiar with, hopefully on the call, is that for the license, you're using terms, the use of the software generally is for the licensee's internal business purposes. Obviously, it would depend on the license itself, but this is quite a common phrase you will see. Now, the use of internal is key here, as it will probably permit the use of software by third parties who are providing services for the licensee on its behalf and whose use of the software is merely incidental to such services. But where the real difficulty arises is in this scenario here, which I'll obviously have to explain it because I don't think the drawing is that good, but the building at the middle essentially is that parent company based on the example I gave before, but in this instance it has the license scope is wide enough for its group companies. Now the dotted line on the right hand side of the screen is that one of these group companies is now being sold off as part of a general restructuring or an acquisition, and so this is where it becomes slightly difficult. So the company who's sold part of its business will now be then, what sometimes happens is you have this transitional services agreement where one company who purchases part of the other company, the purchaser is likely to need short-term assistance and the benefit of certain licenses after completion of the sale in order to allow it enough time to transition the acquired company, so this one here, into its business. So what this means is that for a short period of time, this company is going to need use of a whole myriad of services, but for the purposes of this talk, we're talking about licenses. But you imagine emails and certain HR records and software that the HR record sits in and just a whole myriad of things. And they're going to need this access, however short term. But again, coming back to for the licensee's internal business purposes, that's now tricky, because it's no longer doing it for its internal business purposes. Now, while some licenses provide for divestment language, which I'm sure some of you may have seen, these are really in the minority and reserved for bespoke licenses and for large organisations who can insist upon them. And good examples of these, which we've seen more regularly, are for banks who are very active in corporate restructuring, so it'd be fairly normal to see such a clause. But they've also got the financial clout to insist in such clauses within its contracts. But this is really unlikely to apply for commercially off-the-shelf software, or for just small suppliers or small customers that can't really have the sort of negotiating clout to be able to ask for such things. So as a result, the licensees in such situations may find themselves in breach of their license terms, even if this is for a short duration. And I think, as this is the final point, I think this is certainly something we feel strongly that the software industry should try and address and be more alive to, not necessarily to try and to find their customers and the like, but also to allow opportunities for their customers to be compliant and allow for temporary extensions of licensees in such scenarios, even if this attracts a small fee. And we've certainly seen some suppliers offer that in some instances, but I think this needs to be a bit more commonplace to allow for these, for the corporate transactions that happen on a daily basis, M&A activity. This would really go a long way to help that level of compliance and just make it easier for access. And perhaps this can be something that our co-hosts FAST can perhaps champion over the coming months or coming years. But that's certainly one for us we don't feel gets enough attention, because it really is quite an obvious situation that will arise quite frequently, but just there isn't that practical process whereby a licensee can become compliant in an easy and swift manner, because it's going to need to be fairly quick because of the speed of the corporate transactions and the deal itself, but also knowing, and for obvious reasons, the confidential nature of such deal, they can't give early notice to the suppliers of this. It needs to be able to move quite quickly, that they're going to need to provide this sort of temporary access to this sold off part of the business, and just agree on that and whatever those license fees might be. But I think that's essentially me for those talks. So if there's any questions, I'll leave that up here as well for those that don't necessarily have questions immediately, but want to touch base once they've had some thought on this. Feel free to obviously get in touch. But yeah, happy to answer any questions if you have any.
Thank you very much, David. While we're waiting, oh, we have a question. Okay, so I may not have to jump in. It's something from Alan Turnbull. I don't know whether you want to read out his question before you answer.
No, I think, yeah, it's a really good question, actually. So is it interesting debate on corporate transactions. The question comes in is, where should the responsibility lie? Is it the vendor or the customer? And I think that's a really good question, because really it is the customer's responsibility, because they're the licensee, and they need to make sure that they've got, they've agreed those terms and they need to act in accordance with them. Often we see in these transitional services agreements, these TSAs, these short-term kind of temporary services that will be provided in that period, which will include other things, not just software, but for these purposes, software. You will often have a caveat in there that it will only be to the extent that they can do it in accordance with the license terms. And that's the sort of to try and protect that, and to sort of stop anyone sort of in trying to force them to breach the terms of the contract. But what I think the main point here is, while it certainly remains the customer's responsibility, I see it almost as an opportunity for the vendors, because this just happens on a regular basis with corporate transactions, that these issues will arise so regularly that it could be an opportunity for the software vendors to allow this kind of ease of access for their customers in such scenarios, and actually charge for it, because even if it's because it's going to be a short period, it can be for a short fee. It's recognized that it's only temporary in nature and it will expire, so there is that kind of comfort that it can't be abused and just used indefinitely. But I think yeah, so the short answer is that definitely the customer's responsibility, but I think there's a real opportunity for the vendors generally to it's create a sort of small new market, but it allows everyone to just act in a compliant manner, and just do it in a swift and an easy way, really. Hopefully that answered that, Alan, but thanks, that's a very good question.
I think the ultimate sanction for somebody not complying is obviously litigation, but it's a hard decision to sue, a customer that's paying you 60 million quid. Also that it's not necessarily the case that you would win. What other forms of leverage do the software houses have to get the customer to actually see that it's in their interest and be more compliant? Because I understand the scale of non-compliance, because obviously to comply technically means that you're paying more. It is absolutely huge.
It's a fair one. It's because you're right, litigation is often the last resort across the board, and that's why it rarely gets there. But without a doubt, the sort of the letters that come through to clients around, going to please, we've done our audit and we think this is, you're under license by this amount and please rectify it. It's often, that's usually the way that's the process that's followed, and I think there should be a better way in terms of education, and the software tools are already there, and I think there could, now with cloud, that kind of dashboard ability for the licensors to see who's accessing it, making sure it's within the parameters is there, and I think that software already exists for on-premise solutions. But I think historically some vendors saw that as, well, it's in our interest for them to sometimes be slightly out non-compliant, because then it's either a source of revenue or it can be a leverage to move them to a new platform or something else. And so, but I think we are moving away from that. I'm confident in that, because I know, speaking of SAP in particular, they really have they were quite public after this case. Actually, they started creating a whole myriad of tools, changed some of their metrics to be a lot clearer. And I think that would really go a long way, because the more the customer understands what their rights are, the less justification they have for breaching it. And I think education is such a key one, really, to work in collaboration with the clients or their customers, rather than simply just running an audit and then sort of going after them quite aggressively at times.
Okay, one more question. Yes, can you see it, David? Could you read us out?
Could you touch on objective versus subjective license terms? So I suppose it depends on how I interpret that, but I think I'm assuming it's to do with some of the ambiguity around some of these terms and the difficulties it is to understand what the metrics are and what they're to be held against and what they're to be judged against. I'm assuming that's kind of what we're getting at, and the more it can be clearly tied to something tangible, like a number of users or a number of transactions, the better. Where it comes in, like the SAP case showed, is where you've got directly or indirectly access. Now, just the software industry as a whole is just built up around access, interfaces between other software, and I've got a real nervousness about how this could move to a more kind of subjective view of, well, this software is accessing and is technically using the software or processing a transaction through it, so this should be caught within it. But if each one of those transactions is then deemed to be a named user, it could just wreak havoc for licensees, and the potential fees could just be astronomical. So I'm hoping I answered that right, but I certainly see there's the clearer and more objective nature on the license terms, I think the better, rather than sort of potentially woolly language that could be open to a number of different interpretations. Okay, I think that's
okay. I think that's all the questions, unless we have any more last minute questions there.
But as I said, feel free to contact me directly if you've got further questions. I'm happy to help and just give my thoughts on this quite interesting topic.
Okay then, so we have our final speaker, last but not least. We have Ken Munro, a partner at Pentest Partners, an IT security expert. And he can help us understand and quantify internet security risk for businesses. I believe today it's in the context of Internet of Things.
Great, thank you very much. So what am I all about? I am an ethical hacker. I'm a security consultant, and I spend my time looking at systems that are a little bit out of the normal. So I look at the smart devices that are in our homes and houses, and particularly at the moment, now that we've all had to up sticks through the lockdown and had to work from home, how sometimes those devices in our homes are now maybe threatening the security of the way that we work. So I want to talk you through a number of different things we've been looking at over recent years. But before we go there, I do sometimes wonder why we have smart devices. And I've got one. This is a refrigerator. We've got a couple of these in our office, and it's wonderful. It's got a big screen on the outside and a camera on the inside, so that you can walk up to it and you can see what's on the inside from the outside. But it's about £2,000, and I figure that's a lot of money for not opening the door. So sometimes I do wonder why we have smart devices. Anyway, moving on a little bit. One of the very first devices we ever looked at was my wonderful friend. This is my friend Kayla. She's an interactive talking doll. Some of you might have seen her before. The idea is you have a smartphone, a mobile app, and you give it to your child. She has a microphone and a speaker, can talk to the mobile app, and can have an interactive conversation with your kid. Awesome, eh? If a little bit creepy, perhaps. Now, along the way, we discovered some security flaws with her. Now, the connection over Bluetooth from the doll to your smartphone sadly didn't have any encryption. It didn't have any security on it, which meant that anyone nearby could snoop on your child with something as simple as a mobile phone. So your next door neighbor, someone on the street outside, could listen to the microphone on the doll, and they could also speak to your kids, which is quite creepy. And she's been banned in Germany as a result of that, as well as several other European countries. However, we also discovered we could make her swear like a docker. And let me just see if I can make this work. She's absolutely marvelous, this little dolly. Let's just double check. Yep, I think it's going to work. And we discovered you could tamper with all the questions and answers she made, and as a result of which we could make her...
Hello.
Wait for her. She's great. She's very funny.
Hey, calm down, or I will kick the shit out of you.
Poor innocent doll, hey? I don't know, terrible. Now that was a bit silly. A bit creepy in the context of kids, but we also started looking at things that affect our home Wi-Fi security. And this is a device we looked at about 5 years ago. It's a smart Wi-Fi kettle. And I'm sure many of you are going, well, why do you have a Wi-Fi kettle? Well, the reason you do it, apparently, is so you could have a mobile app by your bed, so when you woke up, you could press a button, and by the time you got downstairs, you had a kettle full of boiling water for your cup of tea, saving you perhaps 30 seconds of your day. Now, unfortunately, along the way, we discovered some issues with the way that it worked. Now, I'm going to show this to you. I'm going to share a command prompt. What we discovered is from the street outside your house, with a wireless device, perhaps something a little bit like this, so a 15-pound wireless antenna you could plug into a phone or a laptop, I needed to do very little to compromise your smart kettle. So I could connect to it using Telnet. We don't use Telnet anymore because that's an unencrypted protocol, but we did. We found a way in. We also discovered it had a password, and unfortunately the password was written in the manual for the chips inside the kettle. We discovered it was 6 zeros, hadn't been changed, and even worse is we could also recover your wireless encryption key from your smart kettle by sitting on the street outside. Now, that might not sound so serious, but if I've got your encryption key, I'm now on your home network. I'm there, and I can now connect to your home Wi-Fi router. And if you haven't changed the admin password on your Wi-Fi router, I can now redirect all of your internet traffic to me, which is a little worrying, isn't it? We kind of hope that maybe security is just a little bit better than this. Now, the good news is the manufacturer finally, after lots of needling from us, finally fixed the vulnerabilities, but it took quite a while for them to get it fixed. More recently, we've been looking at tracking devices. Now, I don't know if, like me, you have young kids, you've ever taken them to the play park, and you turn your back for a moment and your kids have walked off. And it turns out they've just gone round behind a tree or they're on a different piece of play equipment. But it makes your heart race for a few minutes while you're actually searching for your kid. Now, I don't know if you've seen these. These are GPS watches. The idea is you put them on your child, and as a result of which, using a SIM card inside the watch can communicate with your smartphone, and you can track your child in real time. It seems a little bit stalky, but of course, if your kids are little and often wandering off, you probably quite like to know where they are. Unfortunately, the manufacturer of these cheap Chinese watches didn't do a very good job with their security, and actually anyone on the internet with a few moments of understanding how to do this could actually locate in real time all the children without needing to authenticate or ask any more. So they could find where your children were. They could also enable a microphone on the watches because they're effectively a phone. They could spy on your kid, and they could even talk to your child as well. And if you wanted to have some real fun, you could actually re-spoof where your child's location was reported to the app, so it would look like your kid was driving off down the motorway. That would cause you to panic a moment, wouldn't it? We did some work on some others. This was an Australian watch. They'd actually done some good work, and they'd taken the Chinese import, and they'd actually made it a lot more robust and secure, but sadly they didn't get it completely secure. So we discovered we could recover kids' positions, and this is my friend Troy Hunt's. That's his daughter. Troy is an amazing security researcher based in Australia. That is Surfers Paradise, and his daughter was at the tennis club, as you can see just there. For a bit of fun, we decided to rewrite her GPS position and dropped her into the ocean. Obviously this was just a hack, but a bit worrying that through really poor security and really poor attention to detail by manufacturers, they could spy on our kids, move them around, or find out where they were. Pretty horrible. So far, we found nearly 47 million of these watches with security flaws. There have been one or two being banned, so there was a ban by the Icelandic Data Protection Authority. They did a good job there, but just one brand. They banned about 3,000 watches out of about 47 million, which is nuts, right? So talking a bit more about the smart devices in the context of our new working from home way of life. Now, I'm sure some of you has CCTV to keep an eye on your property. maybe on the outside, maybe you've got some safety cameras on the inside of your property as well. And there's been all sorts of problems with these. One of the first issues is many cameras will come up on these devices, which is a digital video recorder. There's usually a hard disk in here that records the feeds from the cameras. And unfortunately, these were badly secured by the Chinese manufacturer, and they were all compromised. About 300,000 of these digital video recorders that take your CCTV feeds were compromised. It was a botnet called Mirai in 2017, and those 300,000 DVRs were all marshaled to create a botnet that took down DNS, which is a DNS service provider behind a bunch of social networks. And it took Twitter off the internet for a while. So that's how bad some attacks can become. IoT devices become botnets. But it gets worse. Maybe you've got cameras in your home. You kind of hope that the manufacturer's got security right, but actually a lot of times the installers don't get it right either. CCTV installers typically understand physical security. They don't understand that you need to change the passwords on your cameras, otherwise people on the internet can hack them. And there's all sorts of cases where people unknowingly have been spied upon by hackers because they haven't changed the passwords on their cameras. I find that quite creepy, right? So if you do have cameras, have you checked that yours are secure? There are even some resources out there. So a search engine called Instacam, which is brilliant for finding insecured webcams. And you can find all sorts, whether it's, I don't know, people's driveways, their horse stables, or even barbers. But there's all sorts going on there. We've even seen them inside people's homes and offices. Now, this particular camera, we've dropped the resolution down some, but it's a high enough res camera that we could actually see what the lady on the right was typing into her screen in real time. So that's one way of grabbing passwords, isn't it? It's also another way of grabbing very personal and sensitive data too. So are you sure that when you got everyone working from home, you also ensured that there were no cameras staring at the screens and no personal data from your customers exposed on those screens that people were working on? It doesn't have to be corporate grade, even people's home cameras like this one. This is a disaster of a home security camera, but most of the cameras we've looked at over the years have had horrific security flaws. Not reassuring. But I would say there is a bit of reliance on the user as well, because if you don't change that password, you're not going to keep the hacker out. Even house alarms. Now, I'm sure many of you have got house alarms. I've got one. You know, I think it's really important that we have an alarm on our houses. Gets our insurance costs down too as well. Unfortunately, over the years we've found all sorts of vulnerabilities in the alarms, whether it's the PIR, so the infrared detectors, we found vulnerabilities in those, so you could jam them. So criminal with a very cheap piece of jamming equipment, costing them about £2 to produce, could jam the PIRs so they couldn't report the fact that they've been broken into, and the house alarm didn't go off. Great, hey, that's reassuring. We've also found remote pin entry pads from house alarms, where you were supposed to be able to put the pin in and that would disable the alarm. We discovered we could actually brute force a 4-digit pin in about 15 minutes and deactivate someone's house alarm from the street outside. Kind of awkward, isn't it? And then maybe some of you have smart doorbells. Ring doorbells getting really popular now. We looked at some of these really early on. This is before they were bought out by Amazon. And we discovered, this is wonderful. So the camera needs to connect to your Wi-Fi. Otherwise, you can't connect to see who's ringing your doorbell. It's screwed to the outside of your house, obviously. We discovered it was trivial to remove the screws. We could pop it off, and there's a red button on the back. And what we discovered, when you press the red button, so you're on the outside of your house, it will put it into a reset mode that we could connect to over Wi-Fi very easily without needing any passwords. And what we discovered in there was by pressing that red button on your doorbell, we could recover your Wi-Fi key. So we've got your Wi-Fi password, now we're on your home network, and now we're capturing all your internet traffic again, just because you wanted a Wi-Fi doorbell. Now, in fairness, Ring, the manufacturer, fixed this very quickly, did a really good job. They had another bit of a mistake a little bit later on, about a month after we reported this. There was some database corruption going on, so if you pressed one doorbell, you got someone else's video feed. I thought that was quite funny. Maybe you've got smart door locks as well. We're seeing these really popular in the US, also quite popular in Airbnbs and short-term rentals. Lots of people are putting smart door locks, so it's easy to use a phone to unlock the door. Great. Don't have to worry about losing your keys anymore. This is the inside of a door lock. We discovered that you could actually reach up to the override key in the base of it and put a little lever in and flick the door open. So by putting in a smart door lock, you made your house more vulnerable. And this one was rather fun. This is another smart door lock. It offered biometrics, so you could put your fingerprint on it, or you could pop a number in, or use Bluetooth on your phone. Brilliant. It was all made of very soft alloy. So we could put one very small drill hole in, took less than 2 seconds to drill the side, put a screwdriver in, just a narrow one, and you could flick up the latch release. So 2 seconds to open your front door. How comfortable do you feel putting in a smart door lock now, eh? We're also seeing, with the move to remote working, lots of scams popping up. We're seeing people phoning up, claiming to be your internet service provider, saying there's a problem on your home wireless router, we need to change it. We need to make some modifications, so you need to make a quick change for us. And people are falling for this. People who are working from home are falling for this. And as a result of changing the DNS, what that does, instead of a web address or an email address or a VPN server address resolving to your company, as it should do, it's sent somewhere else. And instead, it resolves to a fake server, which means the hacker can start intercepting your staff's traffic. There will be some alerts popped up, which is good, but if your staff don't know what to look for, it's not difficult to coerce them. Bit worrying, hey? So it goes to the wrong place. Now, with all of this, the good news is there is some regulation on the way, which I'm quite pleased with. So ENISA are slowly getting there. They're taking their time. They've put out some good practice, and they've regulated slowly in industrial controls, but there's still no mandatory regulation in consumer goods, which worries me a bit. In the UK, I've been quite involved in the UK's DCMS Security Code of Conduct, which is actually being consulted on right now, and there's a proposal to make 3 minimum requirements law for smart consumer devices. I'm quite supportive of this. It's taken a while, but it will be one of the first countries in the world to regulate specifically around certain factors for IoT device security. For example, not allowing default passwords, which is how the CCTV cameras got compromised. Having a vulnerability disclosure program so that security researchers can tell the manufacturers about this, and also committing to how long the product's supported for in terms of security updates, so your products don't become obsolete overnight. I think that's really good. However, one of the best, California Senate Bill 327, which came into force 1st of January this year. I was really kind of pleased about this because the senator that introduced the bill quoted our work and our public research on my friend Kayla, the sweary doll, as being the catalyst to this bill. And it is now mandatory that IoT devices in the state of California, for California residents, must have reasonable security requirements, which is fantastic. I'm really proud that this doll actually made some differences. So that's great news. What I would say to everybody, if you take anything away from this, please ask for evidence of security. When you're buying a product, go and look in the description, see what they say about security. Is there any evidence of it? If there's no evidence, there is no security. If you're in a shop considering buying something, ask about security. Because even if the shop assistant doesn't know, the very fact you've asked questions is going to start raising concerns. Is that a secure product? Is it not a secure product? Ask the questions. Anyway, that's me. We blog about this every day. There's loads of crazy devices on our blog that we've hacked, had a lot of fun with. You can follow me on Twitter at the Ken Munro Show. The company's called Pentest Partners. We do instant response. We help organizations that have been breached, help them get them back on their feet again and do investigations. We also do pen testing. Anyway, hope you enjoyed it. Thanks very much.
That's great, Ken. Thank you very much. We do have a question already for you, waiting. I don't know whether you can see it. It's from Jason Black, and it's, do you have any concerns about older HP wireless printers or Google Chromecast devices found in many houses?
I do, yeah. So older HP wireless printers, they're quite fun because you can often connect them. They operate as an access point in themselves without any encryption in some cases. So it's not that much you can do, but you can obviously print off rude things on your printer. That's quite fun. But Google Chromecast have actually got a quite serious security flaw. And if you read our blog, we've actually got some details on what the problem is. The challenge is you can do what's called the de-authentication attack. So you come along with your wireless card, £15, a couple of free tools, and you can knock your Chromecast off your home network. You can then connect to us, and then you can get your TV to start streaming random content. So if it's your kid's home, you can start streaming scary stuff or creepy things, or you can do something really cool. Because if you've also got Amazon Echo or Google Home, you can talk to the TV and get the TV to start playing video. And the video can be of people talking, instructing your Amazon Echo to do various things. So there's a wonderful fun recording we did with BBC Panorama where we showed how you'd hack Chromecast, take control of the TV, turn the TV on whilst you're out, that starts talking to your Amazon Echo, and then stuff starts happening. So your lights go on, your heating goes on, your curtains open if you've got that sort of thing, or your kettle turns on. So lots of fun things you can do with Chromecasts.
Okay, and I think we have another one. Are there any serious security issues with Amazon Fire Stick or similar common products from Vaughan Chadwick?
I don't know enough about the Fire Stick, I'll be honest with you, but what bothers me is as these devices start to get older, they don't get updated. And if they're not updated, well, updates fix security bugs. So I'd strongly recommend, if you've got any smart device, get onto the mobile app or connect the device to the internet and check for updates, because updates fix security bugs. Amazon are pretty good with security, so if there is a bug, they tend to get around to fixing it fairly quickly. But it does still rely on you going, I need to do an update. So please do check on all your smart device mobile apps, check for updates, and push those updates out to your products, and that'll fix the problems.
I mean, Ken, other than not having smart devices, and I must admit I don't have many, only my Sky Q. Do tell me if there's anything wrong with Sky Q. But if you were not going to how can you, if you're going to buy any of this stuff, how can you check? How can you find out?
You can't, and that's the biggest problem. Is there's no standard, there's no log, there's no central repository. One of the most simplest things you could do is go and Google a product name, search for it, and just search for the name security or vulnerability. Very quickly, you'll hit up on blogs like ours or other researchers that have done similar work to see if people have found security flaws with that device. So just spend 5 minutes on a search engine going product name plus vulnerability and see what comes up.
And we have another one from somebody anonymous. Have you come across security or privacy concerns on the online platforms we're all using for video conferences these days, such as this one? I'm sure David looked into this one, David from Stephenson Harwood.
So the good news is after a bit of flack, so obviously Zoom, they experienced very rapid growth and also a lot of scrutiny. And there were some issues with Zoom early on, but they did get fixed very, very quickly. I think the platforms themselves tend to have fewer issues now because obviously there's huge demand, so huge investment in making them safe and secure. It's often more about how we use them. So just think about, the fact that we're using video today. Just think about the background you've got. Now, Dawn, obviously you've got a bookshelf there. Absolutely right. You've got your classic view. But what if that was actually something more sensitive? So just make sure that you give advice to your staff and think yourselves about what's in the background. I've got a wonderfully fun video of a lady trying to do a conference call, and her husband walks past in his pants. Okay, that's not great. So just really think carefully. I mentioned earlier before I started this call, my dog joined me. It's always all funny, but it kind of put me off. And he popped up here and said hello, and it made me think twice about, well, should I really have my dog in the office, even though it's quiet?
And then there's another one from Vaughan. Are there any firewall-like products suitable for our Internet of Things or smart devices that remove the need to update everything? I mean, that's a gap in the market, isn't it, Ken? You should get in there with something, some sort of product there.
Well, that's a really good one. So about two and a half years ago, there was a product that popped on the market. The idea was you popped it on your home network and it basically secured everything. And sadly, along the way, we and some other researchers found it actually created more vulnerabilities in your network. So that they kind of changed tack. But there's another product coming to market in the next few months that's supposed to do the same thing. We've had a bit of a look at it and think it's got potential, actually. But the most basic thing you can do is what we call VLAN, or segregate your network. So if you've got the ability to create multiple wireless networks at home, you could separate out one for your smart devices and one for your sensitive things so that you're not exposing one to the other. It involves a little bit of technical skill, but it's quite easy to read up about how to set up a VLAN on your home router.
Do we have any more questions?
Dawn, I think there was one in the chat.
Oh, I haven't. People were
so,
asked not to use chat. Can you access that one?
Yeah, I can read that. It's from Alex Hilton. Is there any evidence of industrial state-sponsored Internet of Things hacking?
Oh, that's a really good question, actually. So there's definite examples of industrial state-sponsored industrial control hacking. So power plants and the like have been hacked. Issues like Stuxnet, Flame, and various other big ICS hacks. We're not currently aware of any nation-state graded attacks against IoT, although there have been plenty of attacks that could have been. So Mirai, back from 3 years ago, turned out to be, I think that prosecution has been through actually, but there's certainly plenty of opportunity. The bit that worries me is how things scale up really quickly. So when you're building a botnet, all you're looking for is one vulnerability in one device. You can find the devices on the internet and you gather them into your botnet very, very quickly. So there's certainly potential. There's certainly potential for a lot of CCTV cameras, some of which obviously made in the Far East, some of which made by nation states that were perhaps not as friendly as we'd like to be. We've seen vulnerabilities that were very obvious in some cameras, which don't strike us as nation state grade. We've seen vulnerabilities that were very deeply hidden in some cameras, which suggest that perhaps it was more covert and perhaps espionage based rather than errors of not really understanding security. So I think there is great potential for this. I'm sure it's going on. I haven't got any direct evidence of it.
Okay, I think that's the last of the questions. Thank you very much, Ken. Obviously a very interesting topic because you got most of the questions at the end. But I just want to say thank you very much to all of the speakers. All of the talks were fascinating and very interesting. To everybody for attending in this historic occasion, the first online FAST flag meeting. And thank you to Stephenson Harwood for co-hosting and providing the IT in the background. And don't forget to check out fast.org, our website, for all the benefits of FAST flag membership if you don't happen to be a member at the moment. Thank you very much. I'll bring this meeting to a close.
Thanks, everyone.